On Mother's Day, at 4:11 in the afternoon, my mother-in-law looked me dead in the eye and said, "I regret the day my son ever brought you into this family." I set down my coffee cup, walked to the garage, and took the keys to the Jeep Wrangler, registered under both our names, since 2019. If you've ever been told by someone who raised the man you love that you were never good enough to sit at their table, comment the state you're watching from right now. Then hit like and subscribe before the police showed up at our driveway. Because what happened next is the reason I stopped hiding 22 years of my life. 15 minutes after I pulled out of that driveway, my husband Richard texted me, "Bring the Jeep back right now, or I'm calling 911 and reporting it stolen." I read it once, parked outside a gas station on Route 9, and typed back 4 words. "Be my guest, Richard." 40 minutes later, 2 Loudoun County patrol cars blocked our driveway, lights spinning red and blue against the white columns of a house I paid the down payment on, with combat pay I was never allowed to talk about. That was Loop 1, the legal war Richard was about to open on me, thinking he already knew who he was fighting. That was Loop 2, the marriage that had been dying in silence since a deployment 11 years ago, that no one in that family ever asked me about. And underneath both of those, quiet as a sealed manila envelope sitting in a fireproof lockbox at Fort Belvoir, was Loop 3. The truth about who I actually was, and what it would cost every single person in that driveway when it finally came out. My name is Lieutenant Colonel Elena Marisol Voss, United States Army, retired as of March the 14th of this year, after 22 years, 4 months, and 11 days of service. For 6 of those years, from 2011 to 2017, I served with a military intelligence detachment attached to a Special Operations Task Force, work that still carries classification markings I am legally forbidden to describe in casual conversation, work that meant I disappeared for months at a time to places that don't appear on unclassified maps, work that meant when I came home, I said the word logistics and let people believe whatever version of that word made them comfortable. My mother-in-law, Margaret Colton, 68 years old, a woman who has never worked a single day outside a country club board meeting, decided years ago that logistics meant paperwork, and paperwork meant secretary, and secretary meant I was some glorified assistant her son had married beneath his station. She said it at Thanksgiving in 2019. She said it again at Richard's 40th birthday in 2022, this time loud enough for the caterers to hear. "Elena did clerical work, dear. Nothing dangerous, she just types very fast." I did not correct her. I have never corrected her. Correcting Margaret Colton would have meant explaining things that were never hers to know. So instead, I let a decorated intelligence officer become a woman who types very fast at every holiday table I sat at for 6 years. Richard Colton is 43 years old, a commercial real estate developer who inherited 40% of his father's firm, and behaves as though he built it with his own 2 hands. When we met in 2016, I was on a 2-week leave between rotations, wearing civilian clothes, ordering a whiskey neat at a hotel bar in Alexandria, and Richard mistook my silence for mystery instead of exhaustion. He liked to tell people at parties that he rescued me from the military, that he gave me a real life, a sentence he said so many times over the years that I stopped hearing it as an insult and started hearing it as a countdown clock. He never once asked to see my DD-2114. He never once asked what a bronze star with a Valor device actually required to earn, a medal that sat in a drawer in my closet, wrapped in the same felt cloth it came in, because he never once opened that drawer to look. He built an entire marriage on the assumption that his wife needed saving, and I let him build it, because for 6 years, being underestimated was safer than being known. There is a specific sound the Colton house made every year on the 2nd Sunday of May, the sound of Margaret's heels on the marble entryway at exactly noon. Arriving for a Mother's Day lunch, she insisted on hosting, even though I was the one who did the cooking, the shopping, the flowers, every single year since 2018. There is a specific smell, too. Her perfume, something heavy and floral that clung to the dining room curtains for days afterward. The same curtains I'd hung myself the summer we moved in, using a stud finder and a level, because Richard was in Chicago closing a deal, and told me to just call someone rather than do it myself. I never called someone. 22 years of logistics work teaches you that the fastest way through a problem is usually your own two hands, a lesson that apparently translated poorly into a marriage where my competence kept getting mistaken for convenience. By year 3, I had stopped correcting the record at those lunches. I had learned the particular exhaustion of being the only person at a table who knows the true shape of her own life, and I had made peace, or told myself I had, with letting Margaret's version stand uncontested, because contesting it always cost more than it earned. What I hadn't accounted for was how much that silence would compound, year over year, until the people closest to me had built an entire architecture of assumptions with nothing underneath it but my own restraint. The pension is the number that made this a legal war, instead of a private grief. 22 years of army service, at my final rank, produces a disposable retired pay of $4,190 a month, protected under federal law. But Richard's attorney, a sharp-suited man named Bradley Kessner, had spent 3 months building an argument that my pension, my disability rating of 40% for service-connected injuries to my left shoulder and lower spine, and a survivor benefit designation I'd filed in 2020, should all be treated as marital property, subject to an even split, on top of the house, on top of the joint accounts, on top of a life insurance policy Richard had quietly changed the beneficiary on 8 months before Mother's Day, a change I only found because a document arrived at our house addressed to a lawyer's office I didn't recognize. That envelope, cream-colored, embossed with the letterhead of Kessner and Vance, sat unopened in my glove compartment for 3 days, before I finally slit it open in a parking lot, and understood that my husband had been planning his exit for the better part of a year, filing paperwork behind my back, while still sleeping in the bed beside me every night, still eating the dinners I cooked, still letting his mother call me a secretary across the table, while he said nothing. Bradley Kessner had one trait he never deviated from in 11 months of litigation: calculated condescension, the kind of arrogance that wears a $3,000 suit and calls it professionalism. In our first mediation session, he slid a folder across the table and said, without looking up, "Colonel Voss, my client is prepared to be generous, given that your service record, from what we can determine, doesn't reflect the kind of combat exposure that typically justifies the disability compensation you're claiming." He said, typically justifies the way a man says a word he's rehearsed in a mirror. I did not raise my voice. I asked him, in the same flat tone I used to brief a room of colonels, whether he had filed a FOIA request for my full service record, or whether he was simply repeating what his client's mother had told him at a dinner party. He didn't answer. He closed the folder instead, and I watched his jaw tighten. And I understood then that Bradley Kessner's entire strategy rested on nobody in that room ever finding out what was actually sealed in my personnel file at the National Personnel Records Center. Classification pending declassification review. Request already filed, 6 to 8 weeks processing time. The pending exam that would decide everything sitting quietly on a government server while he built his case on a woman he assumed had no ammunition. Kessner tried the same maneuver twice more before that first mediation session ended, each time with the same calculated condescension, the tone of a man reading from a script he'd rehearsed on other women who hadn't spent 2 decades learning to sit perfectly still while someone underestimated them out loud. The second time, he suggested that my extended absences during the marriage, his phrase for 11 deployments totaling 411 days in theater, constituted a pattern of marital abandonment that should weigh against me in the property division, a legal theory Frank later told me had roughly 0 chance of surviving a judge's scrutiny, but was designed, he said, to make you doubt yourself in the room, not to win in front of the bench. It almost worked. I felt the old, familiar tightening in my chest, the specific ache of hearing my service reframed as a character flaw, and I gripped the edge of the conference table hard enough that the wood left a faint pink line across my palm. I noticed 20 minutes later in the parking garage. I did not let it show on my face. 22 years teaches you that, if nothing else, how to let something detonate entirely on the inside while your expression stays as flat and unreadable as a briefing slide. The third time, near the end of that first session, Kessner slid a printed spreadsheet across the table, a rough valuation of the marital estate that conspicuously listed my VA disability compensation as supplemental household income, a categorization Frank flagged immediately as both legally incorrect and, in his words, an insult dressed up as an accounting error. I remember the particular weight of that folder in my hands, the cheap cardstock, the way Kessner had printed my name in a serif font at the top of a document that reduced 22 years of my life to a single line item. And I remember thinking, with the same cold clarity I used to feel reviewing satellite imagery before a mission brief, that this man had absolutely no idea what was sitting in a lockbox 40 minutes from where we were sitting, and that not knowing was about to become the single most expensive mistake of his professional career. The other woman in this story arrived formally in month 4 of the divorce, though I'd known about her since month 1. Her name is Whitney Sharp, 31 years old, a junior associate at Richard's firm, and her fixed trait, repeated in every single interaction I had with her, was performative moral superiority, the specific breed of cruelty that dresses itself up as concern. At a mutual friend's engagement dinner, seated 4 chairs down from me, while Richard and I were still technically married, still technically living under the same roof during the mandatory separation period, Whitney leaned toward the woman beside her and said, just loud enough, "It must be hard for Elena, watching Richard finally get taken care of by someone who's actually present." Actually present. As though the 6 years I spent flying home between deployments, to sit in a folding chair at Richard's father's hospital bedside, as though the nights I stayed awake, managing his mother's medication schedule after her hip surgery in 2021, while Richard was at a conference in Miami, as though none of that constituted presence, because presence, in Whitney Sharp's vocabulary, meant being physically visible at every dinner party, not being the person who quietly kept a family functioning while absorbing every insult about being absent. The second instance came at a firm holiday party in December, 7 months into the separation, an event I attended only because Frank advised me to maintain a visible, composed presence in shared social circles while litigation was pending. Whitney approached me near the coat check, wineglass in hand, and said, with the exact practiced softness of someone who has mistaken cruelty for compassion, "I just want you to know, I don't think less of you for how the marriage ended. Some people just aren't built for partnership, and that's okay. It doesn't make you a bad person." I looked at her for a long moment, taking in the specific detail of her earrings, small gold stars, the kind Richard used to buy from a jeweler on King Street, and I said, evenly, "I was built for 11 deployments and 411 days without rotation home. Whitney partnership was never the part I struggled with." She didn't have a response for that. She excused herself to refill a glass that wasn't yet empty, and I watched her cross the room in her heels, moral superiority intact but visibly rattled, and I understood that people like Whitney only ever perform concern for an audience, and the moment the audience stops applauding, the performance collapses on its own. Margaret Colton's second repeated moment came at the custody-adjacent mediation over the house. We had no children, but the dispute over who would keep the property where Richard's late father had lived out his final years turned emotional, in a way that mirrored a custody fight. Margaret sat in the front row of that mediation, arms crossed, and when the mediator mentioned my years of overseas deployment as a factor in property contribution, Margaret said, clear enough for the court reporter present to note it, "She wasn't deployed, she was filing paperwork somewhere with air conditioning. Let's not pretend this was some kind of sacrifice." I felt the words land in my chest, the way incoming mortar fire lands somewhere else in a compound, and you feel the pressure change before you hear the sound. I did not flinch. I wrote the sentence down in the small notebook I carry, the same notebook I used for 11 years to log grid coordinates and casualty reports, and I underlined it twice, because I intended to hear that sentence again, someday, in a room where it would mean something entirely different. The sealed envelope had been sitting in my lockbox since the week I retired, a manila folder marked with a case number and a note from a records officer at Fort Belvoir. Declassification review pending. Estimated completion, 60 to 90 days. Subject to court order for for expedited release if requested by presiding judicial authority. I had requested the review myself, quietly, the same week Bradley Kessner filed his motion questioning my disability rating, because some part of me, the part trained to plan 3 moves ahead of an adversary who doesn't yet know he's outmatched, understood that this marriage was going to end in a courtroom, and I intended to walk into that courtroom prepared. I told no one about the request. Not Richard, not my attorney, not yet. I sat on that pending file, the way you sit on a grenade, with the pin half pulled, waiting for the exact second it would do the most damage to the people who needed to hear it. My attorney, retired Colonel Frank Doyle, 61 years old, spent 19 years as a Judge Advocate General officer before opening a private family law practice, specializing in military divorce cases, and the first time I sat across from him, he didn't ask me what I wanted from the settlement. He asked me what my MOS was, what units I'd rotated through, and when I told him, he set his pen down and said, "Colonel, I've read 100 personnel files in my career, and I have never once seen a woman let people talk over her service the way you've let this family talk over yours. That's going to change in my courtroom strategy, whether you're comfortable with it or not." Frank Doyle didn't have a courtroom flourish or a dramatic monologue prepared. He had 11 years of JAG casework and an encyclopedic understanding of how disability ratings, retired pay, and survivor benefit plans are treated under federal law, and he built our case the way I used to build an operations plan, methodically, with contingencies stacked 3 deep, and with a single piece of leverage he told me to hold until the exact moment it would collapse the other side's entire argument. My second ally in this fight never once sat at the counsel table. Her name is Master Sergeant Rosa Delgado, retired, 41 years old, a woman I served alongside for 4 years in the same detachment, and the only person outside my chain of command who knew the specifics of what my logistics work actually meant. Rosa flew in from Fort Bragg twice during those 11 months, not to testify, not yet, but to sit in the gallery, arms crossed, boots polished, wearing her old unit pin on a civilian blazer, silently daring anyone in that courtroom to say something within earshot she'd have to respond to. On the second visit, Margaret Colton actually asked her, without knowing who she was, "Are you a friend of Elena's from her old office job?" Rosa looked at her for a long 3 seconds and said, "I was her team sergeant on 11 deployments." She outranked half the men who tried to send her home early. Margaret didn't have a response for that. It was the first crack in 6 years of certainty, and I watched it happen in real time, and I said nothing, because the crack wasn't finished yet. If you've made it this far, you already know what it feels like to be underestimated by the people who were supposed to know you best. So hit that like button right now and subscribe, because the next part is where the mask Richard's family built for me finally starts to slip. The medical collapse happened in month 7, in the parking garage of the courthouse, 20 minutes before a scheduled deposition. I had been managing chronic pain from the spinal injury for 6 years without complaint. The way you learn to manage anything that would otherwise slow down a mission. But the stress of 11 months of litigation, of sitting across a table from a man reading a script written by his mother and his lawyer, finally caught up with my body, in a way my will could no longer override. I collapsed against the driver's side door of my car, vision narrowing to a pinpoint, my left arm going numb from a nerve impingement that had been building for weeks, and it was Rosa Delgado, there for moral support that day, who caught me before I hit the pavement and called for the courthouse paramedics. Bradley Kessner, informed of the delay, sent a single text message to Richard that a court reporter later confirmed existed in the discovery process. Convenient timing, wouldn't you say? Ask her attorney if this is the same disability she's suing us over. Convenient timing. A man who had never once read my medical file suggested, in writing, that a service-connected spinal injury verified by 3 separate VA examinations was theater, staged for sympathy, on the same day I was strapped to a gurney with an IV in my arm and a cardiac monitor, confirming what 6 years of silence had cost my body. That text message became Exhibit 14. Frank Doyle didn't use it immediately. He filed it, quietly, the way you file a round you're not ready to fire. and told me the same thing he'd told me since day one. We don't peek early, Colonel. We peek once, in front of a judge, when it can't be walked back. The night before the final hearing, I laid out my clothes the same way I used to lay out a uniform before a dawn briefing. Pressed, deliberate, nothing left to chance. Frank had advised civilian attire, nothing that read as a performance. So I chose a charcoal blazer and low heels, and I set my grandmother's watch on the nightstand beside the notebook, with Margaret's sentence underlined twice, because I intended to have both within reach. I did not sleep more than 3 hours. I lay awake running the hearing the way I used to run mission timelines. Contingency after contingency. Kessner's likely objections. Judge Hale's known preferences for factual precision over theatrics. According to Frank's research into her prior rulings, General Whitfield's flight confirmation number, which I had memorized without meaning to. At 5 in the morning, I made coffee I didn't finish and stood at my kitchen window watching the sky go from black to the particular grey-blue of a Virginia autumn dawn. And I thought about the folded flag in my closet, and I thought about 411 days, and I thought, with a calm that surprised even me, that whatever happened in that courtroom in 6 hours, I already knew who I was, and no verdict was going to change that. That certainty was the only armor I brought with me. The courthouse parking garage smelled like wet concrete from an overnight rain, and I remember the specific echo of my own heels against the stairwell, counting the flights the way I used to count clicks on a foot patrol, a habit that never fully left my body no matter how many years passed. Rosa was waiting at the courthouse steps in her civilian blazer, unit pin catching the grey morning light, and she didn't say anything when she saw me, just fell into step on my left side, the same position she'd held on 11 deployments, and something in my chest loosened half a degree at the familiarity of it. Inside, the hallway outside courtroom 4B had the specific fluorescent hum and industrial carpet smell of every government building I'd ever waited in, and I sat on a hard wooden bench beside Frank, watching Bradley Kessner walk past us without making eye contact, a leather folio under his arm, moving with the confident, unhurried gait of a man who still believed he understood the shape of the case he was about to argue. The final hearing was scheduled for a Tuesday in late October, in the Loudoun County Circuit Court. Judge Patricia Hale presiding, a woman with 18 years on the family law bench and a reputation, according to Frank, for having zero patience for theatrics, and an even lower tolerance for attorneys who tried to perform for a gallery instead of arguing facts. The gallery that morning was fuller than a routine divorce proceeding should have drawn, because Rosa had made calls, and word travels fast in a veteran community that takes care of its own. 11 former service members filled the back 3 rows, several in civilian clothes with unit pins on their lapels, one in his dress uniform, because he'd come straight from a ceremony across town and hadn't had time to change. Margaret Colton sat in the front row on Richard's side, dressed like she was attending a gallery opening, and Whitney Sharp sat one seat behind her, closer to Richard's counsel table than a junior associate had any professional reason to sit. The hearing opened with Bradley Kessner walking the court through his argument on the disability rating, calling it, in his opening statement, a rating this court should view with appropriate scrutiny, given the absence of documented combat exposure in the record currently available to this proceeding. Judge Hale looked up from her notes at the word currently, the way any experienced jurist notices when an attorney hedges a claim with a word that implies more information exists. Frank Doyle stood, buttoned his jacket, and said the sentence I had waited 11 months to hear, spoken out loud in a room with consequences. Your Honor, the reason the record currently available is incomplete is that 6 years of my client's service record remained under active classification review until 11 days ago, at which point it was declassified under court-ordered expedited release, filed with this court under seal, and I would ask that we proceed to Exhibit 22. I watched Richard's face change first, then Margaret's. Bradley Kessner asked for a sidebar and was denied. Exhibit 22 was the sealed personnel packet, 31 pages, read into the record, not by me, not by Frank, but by a witness Frank had subpoenaed 6 weeks earlier and kept off both witness lists until the morning of the hearing. Brigadier General Thomas Whitfield, retired, my former task force commander, who drove 4 hours from his home in North Carolina to sit in a witness chair and confirm, under oath, in a voice that filled that courtroom without needing to be raised, that Lieutenant Colonel Elena Voss had served as senior intelligence officer for a classified special operations task force for 6 years, had personally coordinated intelligence operations that led to the recovery of 2 captured American service members in 2014, had been awarded the Bronze Star with Valor device for actions during a compound assault in which she remained at a forward position under direct fire to maintain a communications link that saved 11 lives, and had sustained the spinal injury central to this proceeding during that same operation, an injury documented in an after-action report filed the same week it occurred, 8 years before Bradley Kessner ever called it convenient timing. In a text message the court now had in evidence as Exhibit 14. General Whitfield finished his testimony by looking directly at the gallery, not at me, and saying, "I've read the transcript excerpts from this case's mediation sessions, provided to me by counsel. I understand someone in this family described her service as paperwork in air conditioning. I'd like the record to reflect that Lieutenant Colonel Voss spent 411 days in theater without rotation home, more than any officer in her detachment, including myself, and that the men and women who served under her would tell you she was never once, in 6 years, anything close to a secretary." The word landed in the room the exact way Margaret's words had landed in me 11 months earlier. Except now, it was Margaret's own phrase, thrown back across the courtroom by a 2-star general, and I watched her face go the color of the folder Frank had just closed. That was the callback. That was the sentence that had sat underlined twice in my notebook since the day she said it, returning exactly when I needed it to, in exactly the voice that could make it matter. Bradley Kessner attempted a cross-examination that lasted 4 minutes before Judge Hale cut it off herself, informing counsel that continuing to characterize a documented, court-verified combat injury as theater in front of the officer who witnessed it occur risked a sanctions referral. Richard did not look at his own attorney during that exchange. He looked at me, and for the first time in 11 months, I watched something other than entitlement cross his face. Something closer to the specific shame of a man realizing, in front of a room full of witnesses, that his entire case had been built on a story his mother told him, at a dinner table, and he'd never once bothered to check if it was true. Judge Hale's ruling came down 2 hours later, after a recess, and it was not gentle. She awarded my full disability rating and retired pay protection, exactly as federal law required, unaffected by the marital estate. She found that Richard's beneficiary change on the life insurance policy, executed 8 months before Mother's Day, combined with a financial transfer of $18,000 from a joint account to a private account, traced back to a deposit made the same week the Kessner and Vance letterhead first arrived, constituted a bad faith dissipation of marital assets, and ordered restitution. She noted, for the record, that Exhibit 14, the text message calling my medical collapse convenient timing, would be forwarded to the Virginia State Bar for review of Mr. Kessner's professional conduct. And she said one more thing, off the formal record but loud enough for the gallery to hear, looking directly at Margaret Colton. "This court has sat through a great many family disputes. It is rare that the person most underestimated in the room turns out to be the only one who told the truth from the beginning." Ready for that like and subscribe, because what happened in the parking lot, 20 minutes after that ruling, is the part nobody in Richard's family saw coming, and I'm not skipping it. The aftermath unfolded over the following 4 months, and it did not unfold evenly, because consequences never do. Bradley Kessner was formally reprimanded by the Virginia State Bar in December, a censure that followed him into 2 subsequent job applications at firms that do background checks on litigation conduct. He left Kessner and Vance by February, and now practices out of a strip mall office in a different county, a fact Rosa found and forwarded to me with a single laughing emoji and no further comment, because some victories don't need narration. Whitney Sharp's position at Richard's firm became untenable within weeks, not because of any policy violation, but because the partners who'd watched General Whitfield's testimony from the gallery, 2 of them veterans themselves, quietly stopped inviting her to client meetings, and by spring, she'd resigned to pursue other opportunities that, according to a mutual acquaintance, have not yet materialized. Margaret Colton stopped attending the country club's Thursday luncheons for nearly 3 months, a self-imposed exile Rosa described as a woman finally learning what it feels like when the room talks about you, instead of through you. She sent me one letter in January, 4 sentences long, apologizing not for the words she'd said, but for not asking more questions before I said them. Which is not the same as a full accounting, but Frank told me it's often the most a person like Margaret is capable of producing, and I chose, for reasons that surprised even me, to write back 2 sentences in return, neither of them forgiveness, both of them closure. Richard reached out in March, 5 months after the ruling, not to reconcile, but to say, in a message I read twice before responding, that he'd spent those 5 months rereading the case file Frank had entered into evidence, the actual after-action reports, the actual citation for the Bronze Star, documents he could have requested from me at any point in 6 years of marriage and never once did. He wrote that he didn't expect anything from me, that he understood he'd built a life with a woman he'd never actually tried to know, and that the hardest part wasn't losing the marriage, it was realizing he'd had a hero sleeping next to him for 6 years, and had needed a courtroom, a general, and a state bar complaint to find that out. I didn't write back for 2 weeks. When I did, I told him the truth, that I didn't need his apology to feel whole, because I'd stopped needing anyone's validation the day I watched General Whitfield say my rank out loud, in a room that had spent 6 years pretending it didn't matter. That's not reconciliation. That's not romance. That's just the truth landing where it should have landed a long time ago. Rosa still calls every Sunday, same as she has for 11 years, and most weeks we don't talk about the divorce at all. We talk about her grandson's baseball season, or the new detachment commander she thinks is too green for the job. Frank sent a single email after the ruling, 4 words long. Told you, Colonel, and I've kept it pinned to the top of my inbox since. Not out of vanity, but because it reminds me what it feels like to have someone believe the full truth of you before the rest of the world catches up. General Whitfield sent a handwritten note in November, on stationery with his old command's crest, telling me he was proud, a word no one in the Colton family had ever once used in 6 years, and I read it standing in my new kitchen, in an apartment I chose entirely on my own, with a lease in only my name, and I let myself cry for the first time since the divorce began, not from grief, not from anger, but from the strange, disorienting relief of finally, after 22 years, being seen exactly as I am. I retired my dress uniform to a display case in my new apartment last month, the Bronze Star mounted beside a folded flag, and a photograph of my detachment from 2014, the same photograph Margaret once glanced at across a dinner table, and asked, "Is that from a training exercise?" It wasn't. None of it ever was. And here's what I've come to understand. Sitting with that case every morning with my coffee, in the quiet of a life I built entirely on my own terms, the people who reduce you to something smaller than you are almost never doing it because they've seen the full picture and decided you're less. They're doing it because they've never once bothered to look, and it is not your job to spend your life performing your worth for an audience that refuses to open their eyes. So let me ask you the same question I ask myself every time I catch that display case in the morning light. How many people in your own life have you let define you by the smallest, laziest version of your story, simply because it was easier than making them ask better questions? If that question landed somewhere real for you, you already know what to do before this video ends, because the next story waiting on your screen right now is about the woman who sat in that gallery in her dress uniform and said nothing the entire hearing, until the day, 3 months later, it became her turn to walk into a courtroom of her own. And if you've watched this far, you've already proven you're exactly the kind of person who needs to see how that one ends too. So go ahead and tap that subscribe button right now, because you and I both already know you're not leaving this channel without finding out exactly how her story ends.